of this tripartite agreement. It shall be treated as an event of default under the agreement of sale or allotment cum agreement of for sale or any such agreement or document signed by and between the borrower and the seller for the sale of the said residential apartment. So it shall be treated about, it talks about the documents which has been executed by the builder and this one. 16. In the event of occurrence of default under loan agreement during liability period, which would result in cancellation of agreement as a consequence thereof, allotment as a consequence thereof, or for any other reason whatsoever, if the allotment is cancelled, any amount payable to the borrower on account of such cancellation shall be directly paid to HDFC. Yes. However, it is further agreed between the parties that such payment made by the seller directly to HDFC shall not absolve the borrower from his liability to pay the residual amount, if any, from the outstanding loan agreement. Yes. If the borrower, 17, my lord, if the borrower agrees that it unconditionally, irrevocably subrogates its right to receive an amount payable by the seller to the borrower in the event of cancellation of the agreement for sale of undivided share and agreement to build, both dated so and so, in favor of HDFC, and the act of payment made by the seller to HDFC under the cause shall amount to a valid discharge of the seller of its obligation to pay the borrower such cancellation amount, and all such right, title and interest of undivided share and constructed area will vest with the seller. Now, my lord, these are all the clauses which says what happens in the event of default or cancellation, what will happen to the loan. First, the right action of the bank should be take the they have been subrogated with the rights, call for the amount which is paid to the borrower to repay the same, including if any amount which the builder has to pay to the seller, they have a right to collect. So basically, once there is a default or cancellation or anything, the bank gets a right to collect the money from the builder, who is the real beneficiary of the bank. That is the only thing what we are seeking from. Now, the bank has disbursed. See, my lord, if the builder had not taken the responsibility of the loan, it was for me to go further and prove how developer and banker is involved, how they have played it, how they have manipulated in development. If when the builder has given the undertaking that he is taking the loan, whatever the loan amount, my lord, whether they give discount or not, it is immaterial. Relieve me from the loan. Relieve me from the loan. Still, I have a fight, battle, war against the developer for recovery of money what I have paid from my pocket. Whether I go to ED for that, whether I go to RERA for that, whether I go to consumer case for that, or even some other writ petition seeking mandamus or anything, there are series of litigation between me and the developer for recovery of my own contribution. That is the advance amount. That will always be there. But with respect to loan, based on a tripartite agreement, which has been disbursed by the bank in violation of some rules, and which, since I'm not pressing it because the matter is getting settled.
No, you please argue on that also. What is that? What is the violation from the bank?
My lord, there is, my lord, a concept called pre-EMI in every home loan nowadays. That is, you book the apartment, we give you the loan, and we need 3 years or 2 years to put up construction. So in the meanwhile, whatever the pre-EMI, that is before you take the possession, whatever the interest is there, that will be paid by the developer. That will be reimbursed by the developer. So this is the first inducement on which, after a point of time, the bankers send notice to all the home buyers that you yourself is responsible for the interest as well. It is not the builder. If you want, you pay that amount and you reimburse it from him or not. This is the first. Second, my lord, every home loan, it has to be based on the disbursed based on the construction level. So even before sanctioning the loan, there has to be a inquiry conducted as to what stage the construction has taken place. And this is the very notification which is issued by earlier NHB, later by RBI, because of noticing the favorism by the banks towards the developers, that today I file my application, tomorrow 80 to 85% of the amount will be disbursed to them. In few cases, except 2 lakhs, everything have been disbursed. Only for a formality, the remaining amount will be taken. In few cases, it is 1 lakh. If the loan sanctioned is 87 lakhs, in few cases, they have disbursed 86 lakhs. In few of those wherein they have disbursed 86 lakhs, the construction is still not put up. The disbursement happened on one day, single transaction, way back in the year 2016-17. Till today, the construction is going on. This, why I am giving these example is, my lord, in these
So coming to the facts of this case, what has happened?
same thing, my lord. Same thing.
Go ahead.
That is the problem with this present petition, because it is a group petition. There are no exact, as last time this honorable court had concluded with the same aspect, we cannot decide without each individual's documents when it pertains to this. That is the reason where I'm asking is, permit me, if this honorable court permits me to withdraw this and file a detailed petition individually, grants me the time till then, I can demonstrate even in this case what has happened when it has been disbursed. I'm seeking only permission because all the documents with respect to everyone is not forthcoming. And even now, few of them wants to withdraw it because they want to take the property. Few of them want to proceed with the petition. So in this matter alone, I may be permitted to refile individually, so that I can demonstrate in each case what is the.
Please come. The present writ petition is filed on behalf, the writ petitioners are the water. The petitioners are 16 in number. The writ petition is filed seeking the following for you. The learned counsel appearing for at the time of hearing, learned counsel appearing for the respondent has taken an objection that there are 16 petitioners and each of them are having 16 tripartite agreements, and on behalf of all these persons, one writ petition is not maintainable. Learned counsel appearing for the petitioner submits that some of the petitioners want to pursue the matter and they want to have the secured asset, and some of them are not interested, and in these circumstances, if the liberty is given, he'll be filing independent petitions so that he'll be able to demonstrate before the court what are the agreements and what are the violation on behalf of the respondent bank. It is submitted that there is an interim order in favor of the petitioner operating from the year 2021, whereby the bank was directed not to take any coercive steps. Bank was directed not to take any coercive steps. It is submitted that the protection may be granted for till the court reopens, and immediately he'll be filing the writ petition. Considering the fact that the reliefs that are sought before this court on behalf of the 16 petitioners cannot be considered in one writ petition, everyone has their own as their case, and the relief now at this point of time or what they are seeking is not one and the same. In that view of the matter, this court deems it appropriate to dismiss this writ petition with a liberty to the petitioner to file a fresh writ petition within a period of, it is 40 days.
My lord, it may be made 50 days because including the time for bringing the matter before the
Within a period of 50 days. Accordingly, this court is passing following order. The writ petition is disposed of, giving liberty to the petitioner to file fresh petitions within a period of 50 days from today.
front.
From today, the interim order that is granted, till such time, not the interim order, till such time, the bank shall not take any coercive steps.
Much obliged.
Yes, next.
Number 1.3,
1.2.
1.2.
Yes.
Ladyship, before my learned friend starts, Ladyship, there's a memo that has been filed with respect to the Supreme Court cases that are already going on, wherein transfer has been sought of this particular case. Ladyship, the notice has been issued on 7th of November 2025, and with respect to that, Ladyships, the amicus has taken cognizance of it on the orders of the Honorable Supreme Court, and a report has been prepared and being submitted before the Honorable Supreme Court. The additional facts are such that certain few FIRs against this particular builder has been registered. 4 FIRs are there, and 1 FIR has been attached in the memo itself as Annexure A3. You should have a look at that. Those particular FIRs basically shows
No,
that
you filed a writ petition on behalf of how many? 116 writ petitioners.
Ladyship, I am the counsel on behalf of the petitioners, 9 petitioners in the Honorable Supreme Court. Ladyship asked me to file a memo before Ladyships indicating that there is a case that is already going on in Supreme Court with that transfer petition notice order. So, Ladyship, that memo has been filed before Ladyships to take cognizance of. So, similar matter of a similar issue is already going on in Supreme Court, and similar matter is before Ladyships. So, Ladyship, the cognizance has been taken by the Supreme Court. Ladyship may decide what can be the best solution for it, because there cannot be 2 contrary orders of the Honorable Constitutional Courts. That is my humble submission, Ladyships.
My lord, may I make one submission? The counsel on record, Mr. Rajesh P, is unable to get permission for video conference. I don't know. He just asked me to make the
Who
submission.
is he? The one who is submitted?
I am not sure. I've been informed by Mr. Rajesh Pandian himself that he is unable to get online. The permission is not. It says in the VC that you'll be added to the current court once your case is called. He's not been able to log in. He
His case is not coming up. It's not active user is not passive user. In this case also, my lord.
No,
as
but who is he? Just know he is represented.
not. I just he asked me to.